Hello, everyone, and welcome to this new episode of the Privacy Rules Meet the Member podcast. Today, I'm joined by our colleague from Hungary, from the firm Lakatos Koves. His name is Péter Szanislai, and I'm pleased to introduce him to you all. Hello, Peter.
Hello.
And today we are going to discuss together about the data protection regime in Hungary and which are the most recent changes related to that. We had already the opportunity to speak about Hungary a bit during one of our recent webinars, but today we can go a bit deeper on our discussion. So I would like to leave it to you, Peter. Please go on and let us know what's happening there.
Thank you very much. Earlier, we discussed a little bit about how the GDPR was implemented in Hungary and what changes it brought to previous data protection legislation. But as you said today, we can go a little bit more into the details. So in Hungary, the GDPR was basically implemented in two steps. First, with the amendment of the Hungarian Data Protection Act, and second, with amendments of many sectoral laws. First, I would like to mention the most significant elements of the amendment of the Data Protection Act, which I believe must be interesting for any investors or companies who would like to undertake any kind of activities in Hungary. So the first thing is that before the GDPR in Hungary, there was a central data protection register. So companies had to report data processing activities to the Hungarian Data Protection Authority, and with the GDPR this was abolished. So this is certainly a practical thing for companies. Obviously, they still need to observe GDPR-based obligations, so they need to maintain their own records of data processing activities, but at least they do not need to report anything to the authority.
That's interesting, because this is one of the very few cases in which GDPR means a step back
yes.
of the legislation. That's really interesting.
Yes. I think this must be a kind of Hungarian specialty, because as we discussed in the former webinar, originally we can say that the Hungarian data protection law was in many cases stricter than the GDPR. So for companies in Hungary, actually the GDPR did not bring, of course, in many ways it brought new obligations, and obviously the sanctions are much more severe than before, but in many ways I believe that it made the life of companies somewhat easier.
Yeah.
So another point I would like to mention from the amendment of the Data Protection Act is that now the Data Protection Act prescribes the mandatory review of data processing activities in case of processing activities required by law. This means that if there is no deadline for a data processing activity which is required by any law or municipality regulation, the data controller has to review that activity in every 3 years and just confirm if that processing activity isn't still necessary or not. And obviously, if it's not necessary anymore, they need to finish that activity. So I think this is, I believe this is somewhat surprising. I mean, I haven't heard that this kind of obligation exists in other member states, but it's still important for the companies to be aware of this requirement. Third, I would like to mention that the GDPR does not prescribe the confidentiality obligations for data protection officers, but now the amendment of the Data Protection Act has this kind of rules. So it might be important for companies to review their agreements with their data protection officer, regardless if it is an employee or has an engagement or mandate agreement, because it has to contain a confidentiality obligation for the officer. And there is also another point I would like to mention, that based on the GDPR, the criminal personal data, so the personal data in relation to criminal convictions are not considered as a type of special categories of personal data. However, the amendment of the Hungarian Data Protection Act just ruled that the personal data in relation to criminal convictions are also data types which belong to the special categories of personal data. That is that the same requirements of expressed consent apply for them as a legal basis. So basically, these are the most important and most relevant elements of the amendments of the Hungarian Data Protection Act. And now I would like to talk a little bit about the sectoral amendments, which were enacted in this summer. And these affect actually a huge amount of areas. These amended 86 sectoral acts in Hungary, but obviously we can just focus on the most relevant and most important among them, and also to just mention which sectors these affect. There are amendments regarding the healthcare sector, employment, advertising, and security service providers like CCTV cameras. So I would like to just briefly summarize the most important changes and most important regulations on these topics. So first, about the healthcare sector. Before, in Hungary, there was a separate act which regulated the processing of health data. And for the processing of health-related data, this required the consent of the data subject in a written form. That means that before, a data subject had to give its consent with a signature, like a wet signature or electronic signature. So from the amendment, this is not necessary anymore. So just consent in any form is sufficient. Of course, the consent still needs to meet the obligations or requirements for consents in general. Second, and I believe the most important of all amendments might be in relation to employment. So the labor code was amended in many points. First of all, before in Hungary, employees could request documents from prospective employers, and they could copy these documents. But now they can only require employees to present them the documents, and no copies can be maintained except if a law allows that explicitly. So I believe this is an important point, because in many cases we could see that employers like to copy everything and keep them about employees. Second, about the processing of special categories of data, which covers biometric identifications, and also in Hungary, as I just mentioned, data related to criminal convictions. These can be processed by employers only in cases which are prescribed in the labor code. So basically, we can think about if there is a reason described in the law. For example, the prospective employee would hold a big amount of money. In these cases, the employer can process this kind of special data. Another point, which is very interesting, I believe, is that the amendment of the labor code now basically prohibits the private use of the employer's IT equipment. That means that in practice, it means that well, of course, the employees normally like to use social media on the company's laptops, or like to use the company email address for private conversations. Now the general rule is that this will be forbidden unless the parties have an agreement otherwise. And I think that this might make the life of some employees a little bit harder than before, but if we think about that, before there were many problems, and there were also some official guidelines how some inspections should be conducted in order to protect the right to privacy of the employees. This rule certainly makes a cleaner and simpler situation. And last but not least, there is a rule which makes whistleblowing systems much easier. Earlier, the employers could not process the special categories of personal data for this purpose, but now, if it is the purpose for a whistleblowing system, the labor code just gives the possibility to do so. I would like to briefly mention about the security service providers and CCTV operations. This is also an area where the life of companies got easier after the implementation of the GDPR. Why is that so? Because earlier, the relevant legislation required a consent to process personal data by CCTV cameras. Now it is possible to conduct a legitimate interest test and just use the legitimate interest of the provider or the company as a legal basis. And also earlier there was a very short data retention period for camera recordings that was only 3 days as a general rule, which seriously caused problems, because that's a very short time. So if there is any kind of crime to prove, in many cases that is just found out much after this period, and many companies could not comply with this rule. But now the situation changed to the better, and now it is possible for the data controllers to just adjust the time, how long they retain recordings according to their needs. And again, last but not least, I would like to mention a bit about advertising and marketing sectors. Here is a point where we have a slight problem, because this area remained mostly unaffected with the amendment. And I say this is a problem because the Marketing and Advertisement Act of Hungary, and also the E-Commerce Act of Hungary, requires consent as a legal basis for the processing of data for direct marketing purposes, which I believe it is well known that the GDPR, one of in its preambles, mentions that this type of data processing can be undertaken on the basis of legitimate interest, and this certainly is something which should be aligned with the GDPR, or at least the situation should be made clear. However, unfortunately, the amendment does not address this issue. So in Hungary, if we just look at the member state law, we can see that consent is still required for direct marketing, but in the GDPR we can see that legitimate interest can be also used. So this kind of discrepancy still remains, and in practice it might cause some problems, because of course the GDPR is a regulation with direct effect, and of course it should have precedence over national law. However, we are not aware of how the authorities and how actual legislative organs would treat this situation. So unfortunately, this is a point which I believe is very problematic. But as you can see, in general, I believe that in Hungary, the GDPR brought a situation which is somewhat easier or more released than it used to be before.
Okay, so you basically agree in saying that you have now a more company-friendly regulation than before. That's interesting, because it's something that happened basically also in Poland. I recorded a podcast with your Polish colleague from Poland, and she said basically something really similar in relation to the fact that the GDPR regulation is more related to the use of logic, and the use of logic to protect the data of people, but is not that strict to become, too much to be able to run your business without too many, problems.
Yes,
and that's something really, really interesting. And I think it's also interesting the point that you raised on the use of employee data and the employee ID, because as you surely know, most of the data breaches came out to, because of bad use of means or laptops by the employees. So
yes.
Probably that's interesting to see how your country approached this kind of problem in a way that is slightly different also from GDPR, that is more general, more broader for sure. And of course, advertisement is always a big issue. Is there any other any discussion in relation, for example, to this last point that is ongoing as far as you know, or you are just blind in this moment and just waiting that something happens?
Well, experts and lawyers working on this field and also in the academia are continuously talking about that. This is a point which should be cleared and just need to be put in line with the GDPR, and certainly this is something which still keeps the earlier kind of stricter national legislation. So I am sure that this theme will also be amended sooner or later, but unfortunately we are not aware of the time when it will happen. So until that point, I would advise companies, even if it is harder for them, that to send direct marketing messages, they should be still sure that they have a consent as a legal basis.
Definitely. As a lawyer, you also always prefer to protect in the best way your clients, of course. And just one last question, I would like to know if there are many other practical issues that you face in your everyday activities that you would like to raise to our listeners of today, in particular in relation to your country, of course.
Yeah, well, so as we could see, and I mentioned, although the GDPR brought a regime which is more friendly for companies in terms of data protection obligations, but still it is really worth paying attention to the practice of the Hungarian Data Protection Authority, because they still, in many ways, they still tend to embrace a kind of approach which is very strict, especially so far. We could see this in relation to data breaches, like those companies who were a bit late with reporting data breaches were sanctioned, and not only sanctioned because the sanction itself in this case was not that significant for the companies, but certainly the fact that the names of those companies who were late with reporting breaches were published, and that is 100% the reputational damage for these companies. Although the purpose of the whole GDPR regime is to just have a unified data protection regulation for the whole European Union, it is still, I believe, very important to pay attention, especially for companies who have the main activities in Hungary, to pay attention to the local practices, and just make sure that those are not only the general GDPR-based obligations, but also these local rules are properly observed.
Okay, perfect. Peter, we are running out of our time, so I would like to thank you very much for being with us today and for your very clear and interesting explanation. And I would also like to thank all our listeners of today, and I invite them to follow us on our YouTube channels and on our social media, on LinkedIn, and also on our website at PrivacyRules.com. So thank you again, and I hope to see you again very soon.
Thank you very much for the opportunity.